So today my presentation is about the rights and privileges of home buyers. All the few cases connecting the home buyers I'll be covering, and I will be explaining what is the special rights and privileges given to the home buyers, why they have been given, what is the effect of that, and this is all about my presentation today. First of all, before going to the home buyers, I'll briefly touch upon the creditors and what types of creditors I have. Already, my predecessors have already touched upon this. The types of creditors, there are a company have different types of creditors, and when a company go into CRP process, everybody has their own interests, concerns, and the way they want to address them. Broadly, there are three types of creditor: financial creditors, operational creditors, and other creditors who are not falling in these two categories. Now, I'll give you the definition of financial debt as per section 5.8 of IBC. The time financial debt has been defined to mean a debt along with interest, if any, which has been disbursed against consideration for time value of money. This what is very important. So anything which has been disbursed for consideration for the time value of money is treated as a financial debt. So typically, the creditors whose relationship with the entity is purely financial in nature, such as loans or debt, are covered under financial debt. And who is a financial creditor? Financial creditor means any person to whom the financial debt is owed and includes a person to whom it has been assigned or transferred. So original financial creditor as well as anybody who is a assignee from the financial creditor will also be treated as a financial creditor. Now coming to operational creditor, section 5 subsection 21 defines operational creditor. Operational debt means a claim in respect of the provision of goods or services including employment, or debt in respect of payment of statutory dues to government. So three categories of people are included in the operational debt: the people who are providing goods or services, then the people who are rendering services as their employees, and the statutory dues. All the statutory dues also fall under the category of operational debt. And operational creditor is an creditor to whom operational debt is owed, or again the same way either assigned or transferred. So the basic difference between the financial creditor and operational creditor is very important from IBC point of view, because operational creditor, irrespective of the amount and size of their claim, is not allowed to be part of the COC except where there are no financial creditor. So this is where there is a lot of heartburn. In many times it happens. In fact, I have seen few cases in real estate companies. A bank, for example, has given a 10 crores of loan to a company which has gone into insolvency, and there is a contractor who has rendered services, in the sense that he has constructed a building under a contract of agreement with the real estate company, and say 50 crores are due from him. When the company goes into insolvency and the committee of creditors is formed, this bank which is lent 10 crores becomes part of COC, but the contractor who has rendered services and done the construction work up for amount worth 50 crores is also not paid, made part of the COC. Then who can make an application? This has already been covered by predecessor speakers. The financial creditor under section 7, operational creditor under section 9, and corporate debtor himself under section 10. Then the committee of creditor, I just covered. Section 21.2 provides that COC shall consist of solely financial creditors. Only in exceptional circumstances where financial creditors are not there, then operational creditors also form part of the COC. If there are financial creditors, normally in most of the companies you have financial creditors, only they form the part of the COC. Now, Swiss ribbon case has been extensively discussed by Mr. Alawad Rao. Then, in this also, Supreme Court has observed that the financial creditors generally lend finance and term loan or working capital that enables the corporate debtor to either set up or operate its business. On the other hand, Operational creditor, relatively, whatever they provide is for the supply of goods or services in the operation of the business. Finance contracts are generally involves large sums of money, and operational creditors in general, there may be exceptions, but in generally operational creditors do services for a quantum which is reasonably lesser than compared to financial creditors. Now coming to status of home buyers, this is where the entire problems have come up, challenges have come, controversies have come, because originally when the IBC has been promulgated, home buyers were neither covered under the definition of financial creditor or operational creditors, and as a result of that, they were not given a seat in the COC. But in reality, what happens is that real estate sector majorly runs on the money of the buyers or allottees rather than the financial investors or lenders. As you know that in most of the banks and other things, it more or less real estate in the negative list of things, and banks and institutions not so easily lend money to the real estate companies. Whereas whenever a project has been announced, the major chunk of the initial finance comes from home buyers only. So for typically, if you see any city, including Hyderabad or Delhi or Bombay, in fact, places like Delhi and Bombay, things are very costly. Each flat may be costing something like 2 to 3 crores. Even in Hyderabad, maybe a flat may be costing a crore. Suppose if a project of say 300 to 400 apartments has been announced, so the amount to be contributed by the allot in itself runs to 400 crore rupees. So normally what I said, after beginning of the construction and other things, 60 to 70% of the amount is collected. That means close to 2 to 300 crores is collected from the home buyers, and against that maybe some loans are given by the banks to the extent of 50 crores or 100 crores, whatever it is. So at any point of time, if you compare home buyers, money contributed by home buyers is much larger than the money contributed by any other creditors, including financial creditors. But the problem is that initially they were not given a seat in the COC. Since June 2018, a total number of 1861 cases have been filed at various NCLTs against the builders, which amounts to 20% of the total number of cases filed. So, as a segment, if you see, so this is one of the biggest segment of the cases in the NCLTs, various NCLTs. So, considering that each project, thousands of flat buyers are there, right? For example, JAL itself had 25,000 flat buyers. The number of people who suffer if a real estate company goes into insolvency is much larger compared to any other segment of creditors are concerned. So understandably, this has led to a lot of resentment and litigations, since home buyers were not given a seat in the COC, and also now priority in the waterfall. Now, a lot of petitions have gone for home buyers right. We will discuss few of those cases. One of the famous cases is that Nikhil Mehta and Sons versus AMR Infrastructure. So in this case, an application triggering insolvency was filed in the principal bench of New Delhi. So the NCLT was required to decide in this case whether an agreement for a committed return or issued return from the date of execution of the agreement till the actual payment, actual physical possession of the unit should be treated as a financial creditor or not. So NCLT has gone into the case, and NCLT has answered the issue in negative. They simply say that agreement to this is an agreement to sell, though there is a clause for payment of return of issued amount, but the default of that amount doesn't translate into it being categorized as a financial debt. This is the judgment of the NCLT in this case. But aggrieved by this, an appeal has been filed with NCLAT, and NCLT held that the applicants who are issued returns as per the agreement are to be treated as financial creditor within the meaning of section 5 subsection 7 of the code. So NCLT has accepted the committed returns as consideration for time value of money. This is what the definition of a financial debt, that If there is a consideration for time value of money, it will be treated as a financial debt. And in case of issued returns by a home buyer, the NCLAT has held that it should be treated as a financial debt because there is a consideration for time value of money. So, what NCLT has held is that in this particular case, in such cases, the money is simply advanced by the home buyers and they received the benefit under the committed returns. So, this demonstrates that the committed return to the LRTs were in consideration of advance payment. So, there is nothing other consideration is there. The money is given. Of course, underlying asset is there. Ultimately, asset has to be given, but till the time that asset is given, there is an agreement to pay a return. No other thing is involved in that. You have given the money, he is giving you return. Ultimately, for that principal, of course, he is not returning the principal. For the principal part, he is giving you the flat. But till the flat is given, the only terms and condition is that you are giving money, he is paying you a agreed return. So that is assuming the color of a financial debt. That is what NCLAT has decided in this case. Then NCLTA has also held that this agreement which has been entered into between the flat buyer and the real estate company is in the nature of instrument to raise money. So whether you are going to a bank and raising a loan, and whether you are going to the LOT and taking money under this agreement, both are treated to be the same instrument for raising money. Similar views also given in a few cases like Neelam Singh versus Megasoft Infrastructure, Anubati Agarwal versus DPL Builders, and Pawan Dubey versus JBK Developers. So with this, what happens is that among the flat buyers also, two categories of flat buyers have got formed. One is with assured return, who will be treated as financial creditors. Other people who are without assured returns, who will not be treated as a financial creditor. So till that point of time, right, not all flat buyers are treated to be financial creditors. Apart from giving the money, in some schemes, real estate companies is to announce that till the possession we will be giving you a return for the money which has been deposited by you, right? So please note, only in those cases where there is an agreement for a return of money till the possession is given, they only were treated as financial creditor. Only vanilla agreement per se that I have deposited the money with you, after 2 3 years or you are supposed to give me a flat, whether you give in time or whether there is a delay or not, I will not be treated as a financial creditor. So that is the difference between assured return schemes and non-assured return scheme. Then an interesting thing has happened that, as we know, that Jayprakash Industries case has really has changed the rules of the game because of the large number of people who have suffered. More than 25,000 flat buyers were there. So they also gone to Supreme Court with a lot of cases. A lot of cases were pending at various forums, including Supreme Court. So to give relief to the home buyers of Jayprakash Industries case, a specific form has been introduced which is called as Form F. So what happens is that there are different types of creditors we have discussed. Financial creditor are supposed to file a Form C for their claims, right? Now in this case, IBB has amended IBBI insolvency process for corporate persons and introduced a Form F for the flat buyers. So announcement has come on 16th of August 2017 under Regulation 9 was inserted, wherein a Form F has been introduced for claims to be lodged by home buyers. Even at that point of time, they were not treated as financial creditors, but some special category has been made. Neither you are an operational creditor nor you are a financial creditor, but something to be decided in future, they wanted them to be a special category of people. So form have has been introduced and these people were asked to file Form F. Now the question comes, what is the difference between Form C and Form F? Obviously, the home buyers cannot file Form C, because they were not treated as a financial creditor unless there is a agreement for issued returns. So, in case of Form C, they will be treated as a financial creditor number one. As a result of that, they will be part of the COC, and in the waterfall mechanism, when ultimately the money is to be distributed if the company goes into liquidation, the people whose claim has been admitted under Form C, that is treated as a financial creditor, will get a priority over the claims of employees other than workers, unsecured creditors, government taxes, and preference and equity shares. But the people who are filing Form F were not given all these privileges at that point of time. Now coming to Chitra Sharma versus Union of India case. A number of writ petitions under section Article 32 were filed before Honorable Supreme Court in Chitra Sharma and others versus Union of India. Some of the serious concerns which were raised, which are very very important from the home buyers point of view, are the follows. The home buyers have not been included in IBC, and it is discriminatory, and fundamental rights are of their right to life as recognized under Shanti Star Builders versus Narayana Khemka Totme case has been affected. Not included them either as a financial creditor or operational creditor deeply prejudices them by rendering their disentitled to be part of the COC, while home buyers are the biggest contributor of finance in real estate companies by way of advances or installments which they pay. This is a very very important contention, because when the company goes into CRPC, every decision in respect of the process is taken by the COC. So various judgments are there where NCLT has admitted that COC is the ultimate. Decisions taken by COC are the ultimate. Even NCLT and NCLT doesn't prefer to interfere in the commercial judgments made by the COC. So entire process of the running of CRP process, plus ultimately selecting who is going to be the resolution applicant, whose bid will be accepted, will be decided by the COC members. So if the flat buyers, because of their not being categorized as financial creditors, are not given a seat, many a cases it will happen. Of course, it surely is to happen that you may be contributing 70 to 80% of the total debt of the company, and somebody like a bank or other institutions who are by nature categorized as a financial creditor are taking all the decisions by which you two are bound. So this is another important, very, very critical thing which has been raised in this particular issue. Then another important thing is that when the case get admitted in NCLT, a moratorium is granted. Moratorium period starts under section 13 and 14 of IBC, and different remedies available to the home buyers under RERA, civil courts, consumer courts, all will come to an end. As you know, when the moratorium starts, no fresh case can be filed, or no case which has been filed can be pursued till the NCLT decides upon this CRP, the case which has been admitted in NCLT. So with one stroke, till that point of time, the home buyers have a lot of remedies, especially under RERA. RERA is also very very potent and effective, so-called effective measure available to them to get their grievances addressed. But the moment the moratorium starts, all that will come to an end. So, to secure justice, the Supreme Court has held that the CRP process should be revived and COC reconstituted to include home buyers. So this is the first time the Supreme Court has decided to reconstitute the COC to include home buyers. Financial creditors are entitled to voting share proportionate to the extent of their financial debt owed together with 8% interest. In this particular case, suppose there is a, you have booked a flat for 1 crore of rupee, you have paid 50 crores, 50 lakhs out of that. So when the case has been admitted, whatever amount you paid to the builder plus 8%, what it constitutes after the total debt which is due from that company, that is the percentage of share which is given it to you. So that is the way the voting happens. The proportionate of your debt to the total debt, proportionate to the debt means your principal as well as the interest which has been admitted in the claim, that will determine your voting power in the COC. Then based on this judgment, on July 13, 2018, a circular has been issued by IBBA in pursuance of Regulation 16A to facilitate the process of appointing authorized representative for a class of creditors governing by Section 21 of IBC, which included home buyers also. So I will discuss in the next slides what is the concept of AR. So briefly telling that there will be large number of home buyers. Now, though they are being admitted in the COC, say for example, a case like JIL, Jayaprakash Industries, where 25,000 flat buyers are there. On an average, any real estate company project you take, there will be something like 300 to maybe 1,000 flat buyers will be there. So whenever you hold a meeting, you cannot permit all of them to attend the meeting. Then otherwise there will be chaos and it will not be really practical to hold a meeting. So by this circular, IBBA has introduced the process of authorized representative. So all the home buyers, though treated as financial creditors and given a seat in the COC, they are not permitted to attend the meetings, and they have to attend the meeting through a qualified insolvency professional to be appointed as an authorized representative. Then Amendment Act 2018, on 17th August 2018, Insolvency Bankruptcy Amendment Act was passed. By virtue of Section 3 of the Amendment Act, the following explanation in Clause 8, subsection F has been added. Based on this judgment, the explanation says, for the purpose of this subclause, any amount raised from an allotee under the real estate project shall be deemed to be amount having a commercial effect of borrowing. So by this explanation, all the controversy, all the confusion relating to the home buyers has been put to rest. It says that any amount raised shall be deemed to be an amount having a commercial effect of borrowing, and the expression allotee and real estate project shall have the meaning as given in the RERA Act. So I am actually using the word flat buyer, so people may have a confusion. When I say flat buyer, is it only for residential flats or is it for everybody? Actually, the proper term should be used is allotee. Here the term allotee has been used. If you go to the definition of allotee under RERA, it includes everyone, whether it is a residential, commercial, or mixed use, or whatever it is. Any project which has been announced by a real estate company for a residential purpose or a commercial purpose or for whatever other purposes, including a warehouse, all these people are put under the definition of allotee. And when I refer to a flat buyer, just it is generally these are the words are used. I am also using that word, but the proper word is allotee. Allotee means all, including the commercial projects as well as residential projects. So these are the terms we have to borrow from RERA. Home buyers are now at par with other financial creditors in the code, and any home buyer now can trigger the provisions of IBC, and if there is any delay or refusal to return the money by the developer. So whatever grievances you may be having with a real estate company pertaining to a refund of your money, suppose today I book a flat, he will promise that I'll give you after 2 years. If he delays, maybe after 6 months or 1 year, if I don't want to continue with that the company, I can ask for the money back the day I issue a notice to him requesting to pay me back my money. the amount is due, and that entitles me to file a case against the real estate company. In the same way, if for any reasons you want to withdraw from the project also, if there is any delays and whatever may be the reasons, if you ask back for the money, if the money is due, then you, being a financial creditor, have a right to file a case against the real estate companies. Now, another important judgment is Pioneer judgment. The Supreme Court in Pioneer Urban Land and Infrastructure Limited versus Union of India has upheld the constitutional validity of Second Amendment. So, the builders have gone to the Supreme Court and challenged the amendment itself, wherein the home buyers have been categorized as financial creditors. So, here, the three judges bench headed by Rohinton Nariman has disposed of the bunch of 150 petitions filed by the real estate developers challenging the constitutional validity of this amendment. And in this case, SC held that RERA has to be read harmoniously with IBC, and in the event of any conflict between IBC and RERA, then IBC provisions will prevail. So here a question has been asked that, the provisions of IBC where these people are being treated as a financial creditor are going against the provisions of RERA. So then the court has decided that they have to be interpreted harmoniously. So, and SC has emphasized the fact that the amount raised from the home buyers contributes significantly to the financing of the construction of such flats and apartments. This is what the contention of the flat buyers right from the beginning, that in a project our contribution is the major, and SC has given assent to that, saying that yes, they do contribute significantly for the project. And this being the case, the legislature considered it important to insert an explanation clarifying that the home buyers are to be treated as financial creditors. So it has given a stamp of its authority that the amendment is right. Then further, the Supreme Court has clarified that while concluding, it said home buyers under the real estate agreement with profit as the main aim as subsumed within the meaning and the definition of the financial debt under section 585, and explanation which has been put in by the amendment is only clarificatory in nature. So Supreme Court has gone to the extent of saying that right from the beginning of IBC, the home buyers should have been treated as financial creditors only, and this explanation which has been inserted by the Amendment Act is only a clarificatory in nature, so that henceforth there is no doubt about it whether home buyers should be treated as a financial creditors or not. So by these important 2-3 judgments, so all the controversies pertaining to the home buyers have been brought to an end, and now there is no doubt or no denying of the fact that the home buyers are financial creditors. They have to be given equal right along with banks and institutions and whatever other categories of financial creditors in the COC, in the decision making, and ultimately in deciding who will be the ultimate resolution applicants whose proposal will be approved in a COC meeting. Now coming to the authorized representative, which I briefly said that the concept of authorized representative has been introduced. So section 21 subsection 6a b of insolvency bankruptcy code read with regulation 16(1)(a) says where corporate debtor has at least 10 financial creditors in a class. So not necessary only home buyers, in any category of financial creditors, if there are 10 or more people are there, the IRP professional, while releasing the first advertisement regarding CRP process, has to give an option of 3 registered insolvency professionals, and a creditor in a class may indicate his choice of the insolvency professional from among the 3 to act as authorized representative along with his claim. So when advertisement is released, apart from all other details, 3 names will be given of a registered insolvency professional whom you have to vote to represent you in the meeting. As I said that all the flat buyers will not be permitted to attend meetings, right? They have a right to vote, but as far as the meeting is concerned, it is the authorized representative who will be attending on your behalf. So out of the three, the resolution professional who gets highest number of votes from the flat buyers or the financial creditors will be appointed as an authorized representative by NCLT by an order. So whosoever is chosen, normally unless there is some problem with him or some disciplinary action is going against them or something like that, though they will be appointed as an authorized representative. So AR shall attend all the COC meetings on behalf of the financial creditors, and most importantly, AR collects the voting instruction from the respective class of creditors and casts vote in accordance with the instruction given. As you know that the entire process is done, voting is done through e-voting process. So it is a two-way stage when different resolutions which have been discussed in the COC, where authorized representative attend on behalf of the flat buyers, then all those resolutions are put for voting. Then in the first stage, all the flat buyers vote, right? And that voting results are actually comes to the air authorized representative only. That means it is treated to be an instruction to the AR that this is what we have decided in respect of these resolutions. Then on the next stage, AR will vote on behalf of the flat buyers. So it is a two-way stage of voting is done. Now, coming to the voting process by authorized representative in respect of financial creditors, this is also very interesting development has happened. IDVA versus Jayaprakash Infra Limited. So, the requirement of vote by each home buyer being calculated individually in proportion to the individual debt owned by him has its own challenges. So, earlier what is to happen is that कि there are say certain number of home buyers, their share is there as a percentage of the total debt, and if all of them vote, right, if all their voting is to be considered, then it is to happen that many of the resolutions were never passed because of abstinence by large number of people. This is what has been held in IDVA versus Jayaprakash Infrastructure, that none of the agenda items put forth before the committee of creditors were approved, mainly due to many home buyers failing to exercise their vote, and thus remaining financial creditors whosoever is voting, even if majority of them want or don't want some resolution to be passed, it was of no consequence, because overall whatever percentage has been fixed as 51% or 66% or 71%, 75%, whatever it is, it never is to muster that required number of votes or percentage of votes. So most of the resolution is to fall. So the amendment to section 25A of the code provides that for cases where authorized representative is representing a class of creditor, such representation will vote on behalf of the entire class on the basis of the decision given by majority whom he is representing, and those who are present and voting. This is very very important, present and voting. I don't know where the confusion has come. In all the meetings, this should be the principle as far as the Companies Act is concerned. In the general body meetings which we used to hold as a company secretaries for many many years, or any association or anything which you are associated with, whenever we talk of voting, it is always present and voting. But somehow in the CRP process, there was earlier there is a confusion. When you say 51% of the total voting share or 75% or whatever percentage it is treated to be the total voting. So if majority of them abstain, so rest of the people, even 100% people vote in favor of something, the resolution never is to get passed because the total voting was not there. So this has been put rest by this amendment. The amendment now clarifies this issue by empowering AR to cast vote of the entire class of creditors represented by him, but the decision approved by more than 50% of the class of creditors. So this is very very important to understand that as a AR, when voting is done, right, whatever decision comes, if it is yes or no, right, suppose if 51% of the people say yes, 49% of the people say no, I suppose if I am authorized representative, I will not go and say it is 51% and 49%. I will not say 51 said yes, 49 said no. I'll say it is yes. Yes means the entire class I am representing, right, is said yes to that. So there is two stage, it is actually class voting, not a individual voting. So it has been clarified by this, it is a class voting, not a individual voting. I gave an example, I think this will make the things very clear to you. For example, there are 100 home buyers and collective debt of the 100 home buyers comes to 70% of the total debt of all the financial creditors, right? Out of which, say 30 home buyers attended a meeting of the COC and 27 votes in favor of a particular agenda. So this is the scenario. Total is 100, 30 people attended, 27 people have voted in favor of it. So pre-amendment, what is to happen is that total voting was taken as 20 by 27% of the people, and suppose if some resolution wants 51% or 75%, in this scenario it will be treated that the resolution is not passed because only 27% of the people only voted in favor. Actually 30 only voted and 20 in favor. So remaining 70 people have abstained from voting. Because of the abstinence, the voting has the resolution has not gone through. So, post amendment, the scene has changed. Post amendment, in our example, because of the majority of the home buyers, that is 27 home buyers out of 30 present, have voted in favor of the vote of the entire class of financial creditors, that is 100 home buyers forming 70%, will be treated to have voted in favor of the resolution. So when authorized representative is voting, my voting share as an authorized representative of this class of creditors is 70%. So when majority of the people, that means the people who have voted, 27 people, right, that means out of 30, 27 people, 90% of the people said yes. That means it is above 51. When it is above 51, the resolution is yes. Resolution yes means by how many people? The entire class. Entire class is how much? 70%. So though I will go further, then I will vote, my entire voting 70 is yes. Not that some people have abstained, 30 people, 30%, 30 people have voted, only 27 in favor. I will not go and say only 27 people have voted in favor of that. I will say it is 70% of my class said yes to that. So this is a very, very important amendment by which the CRPC process now is moving very smoothly, and invariably you have to take a call whether it is yes or no. There is nothing like in between. So a group of people cannot come together and abstain from voting and hold the CRP process to ransom. Now there are few hardships which are being faced by real estate company. Not that every time the flat buyers are only the sufferers. Sometimes the other side also we have to see. With this amendment treating home buyers as a financial creditors, there were a spate of cases being filed by NCLT. So this is of course I worked in four real estate companies, leading real estate companies in Delhi. Yes, there is no denying of the fact that there are bad fishes in the market, and maybe their number is unfortunately bit large also. But there are some very good home buy real estate companies also who does a good job and deliver in time. And I don't want to take names this side or that side, but you all people know that who are the good companies. But because of this amendment, all the entire real estate industry suffered a lot because there is a large number of cases being filed by home buyers. And let me tell you that not 100% of the home buyers are also right. But there are a lot of speculative investors, there are a lot of speculative buyers. Today a project is announced, like in the stock market, somebody gives a tip, somebody says something, this जैसे हैदराबाद में तो गच्चीबोली में तो some साइबराबाद बन जाएगा, ये बन जाएगा, वो बन जाएगा. So a lot of things spread word of mouth and people invest. Subsequently, something happens if the project doesn't take off, if that area doesn't take off, and the returns which you are expecting are not coming through, then you also start backpedaling, and you don't pay your installments in time, and all those things happen, because which actually they may be delays. As I said, that majority of the money is contributed by home buyers. A small amount is being contributed by banks and financial institutions. So if the home buyers don't pay the installments due in time, then definitely the real estate project is going to be delayed. So in the same way, another aspect is that to bat for the real estate companies, there may be some bureaucratic issues, then approval issues, then a lot of red tapeism goes on, because of which their projects get delayed. But because of this, earlier 1 lakh rupee, which is a very small amount. So just imagine, if any person who pays 1 lakh rupee is entitled to file a case against you. Now it has been of course increased to 1 crore, but earlier it was only 1 lakh. Everybody who books a flat in any of the real estate projects get entitled to file a case against the company in NCLT. So that amount was too small, as a result of which large number of cases have been filed, which actually are nothing but recovery cases. It has always been said by various NCLT orders or NCLAT orders that don't use this forum as a recovery mechanism. It is a resolution mechanism. So if you see that, yes, default is the criteria by which you become entitled to make an application with NCLT, but the object is not to recover your own money. So it is not a recovery mechanism process or anything like that. It is actually a resolution process. If you feel that there is something wrong with the builder or a real estate company or any company for that matter, and you want the management to change, somebody to be taken over, you want to explore the possibilities of this company going to resolution, right, and somebody taking over, then only you make an application. Not that some 10 lakhs are due from a real estate company or any other company, then I just use this NCLT and the CRP process to recover the money. So because of this, lot of time, effort, money and efforts have gone. I know real estate companies, if you have legal department, earlier there used to be a legal department with say 10 guys. Now after this thing has come, NCLT and the CRP process has come, you have to have some 4 or 5 people exclusively dedicated to NCLT matters. Now each real estate company will have a segment of a department exclusively looking after the NCLT matters. So you don't know which bench, which place, if a case is filed against you. By chance, if you don't attend to that and get admitted, you are out of the company altogether. So representations were made by the real estate company to put a minimum number of flat buyers as eligibility criteria to file an application with the NCLT. With this, amendment has come in 2020. By virtue of section 3 of the amendment 2020, following provisions were added to section 7 of the code, which says, provided further that the financial creditor who are allottees under a real estate project, an application for initiating corporate insolvency process against the corporate debtor shall be jointly filed by not less than 100 of such allottees under the same real estate project, or not less than 10% of the total number of such allottees under the same real estate project, whichever is less. So now onwards, each single individual with a earlier 1 lakh now increased to 1 crore, even if you are paid more than a crore, you cannot singly go and file a case. You have to get 99% of the people or 10% of the total number of allottees in that particular project. Mind you, it is a project, not the entire company. So if suppose a company has 4 different projects, right, total maybe whatever the number of allottees in your project, right, in Hyderabad, suppose if you have a project in Gachibowli, right, in that there are say 300 people, that means 300 10% of the people, that is 30 people, or 100 people, whichever is less, that means 30 people can come together and file a case. Suppose if you have say some 2000 people, right, then it will be higher. So now it has become like a class suit, not a individual suit. Now again, there is a lot of challenges faced by flat buyers. Sometimes these people are happy. Sometimes real estate company people are happy by various amendments. So here the contention is that every legislation made is kept in view of the practical considerations and hazards involved in the implementation of it. But unfortunately, 2020 amendment is highly impractical because this is the contention of course flat buyers. It is not feasible for a single home buyer to obtain information, consolidate the data, contact other home buyers, and then persuade them to file an application. See, what happens is that whenever, in any case for that matter, in life, if you have a problem, you are permitted to file a case individually, whether it is a civil, criminal, recovery, commercial, whatever it is. What you have to show is that yes, there is a contract, there is a breach of contract, there is a breach of terms and conditions of the contract, and I am entitled to file a case, right? Nowhere it is required that you have to garner a strength of the people to file a case. Then this is the contention of the people. Yes, practically if I see today, suppose if I in a project I have paid some 10, 20, 30 lakhs, whatever it is, right? If 30 lakhs has put in any other thing other than the real estate company, I can jolly well go and file a case individually. But with this amendment, what happens is that even if the same amount is when put in particular project, I am being a single person, I cannot knock the doors of NCLT, right? I have to have other 99% of the people are whosoever makes that 10%. Then it many times it becomes very difficult that I may not be having the sources or wherewithers to go and contact so many people, then I make them understand, all coming together, then filing a case. Then more bizarre than this is that when this amendment has been passed, it has been all the cases which have been filed with NCLT and pending admission in NCLT, this particular amendment has been made applicable to them also, and they are obliged to fulfill this requirement of 10% or 100 within 30 days of enactment of the act. Otherwise, that application is deemed to have been withdrawn or dismissed. So in those cases, it is more difficult that when I've already filed a case individually and it is under process at the NCLT and this amendment has been made applicable to those cases also, that I have to bring the remaining people and I have to demonstrate that yes, I have 100 people or 10% of the people, now go ahead with that application. Otherwise, you have to withdraw your application, then gather all these numbers and again refile the case. Then the biggest practical difficulty is that it is very difficult to get information from the real estate companies. Today, if I am a sufferer, if I have some dues from the real estate company or have some grievances against the company, if you go to the company and say, give this information, he may not be willingly give. First of all, I may not be knowing how many flats are there, right? So how many have been announced, how many have been booked? Suppose there may be some, say 500 no apartments which are to be built, construction is going on. So I have no means to know how many people have applied and what is the number, and I have to calculate a 10% of that. So when I go to the real estate company, he may not be cooperating with me because I'm asking some information to file a case against him. Who will cooperate when you say that I want this information to file a case against you? So this is all these are practical problems. The people don't know how many number of flats are there. Though of course there is a way of knowing it, that in case of a RERA registered projects, some details are required to be given for getting a RERA project registered. But the practical thing is that most of the RERA information which has been filed with RERA are not updated on a continuous basis. So it's quite possible you take all the efforts and go and file a case and wait for 6 months or so. The other real estate company will simply come and say that technically, sir, this fellow has to have 100 people or 10% of the total number of people, and my total number is this. He has filed with this number, so it is not actually fulfilling the requirement, and the case may get dismissed. So these are the practical problems which real estate flat buyers are facing. Now, that is the reason a writ petition has been filed challenging the constitutional validity of the amendment, and it is pending with the Supreme Court. but taking cognizance of the home buyers petitions regarding their petitions before the NCLT, SC has ordered a status quo. So all the applications have not been accepted, but at the same time not rejected also. A status quo is maintained as of now. Whenever Supreme Court takes a decision on this, whether this criteria of 100 or 10% is appropriate or not, then it will give some relief to the home buyers. Now increasing the threshold limit to file application on 24th March 2020, Government of India, in excess of the powers conferred under Section 4 of the IBC Code, has specified 1 crore as the minimum amount of default for the purpose of triggering of insolvency. So all these measures are come after the pandemic. Till pandemic it was only 1 lakh rupee. Of course, there was always an argument that 1 lakh is too less, but at the same time 1 crore is too large also. Sometimes the government decisions go from one extreme to the other extreme. This is the best example. So they have gone from one extreme. We thought that 1 lakh is too less, especially especially in case of real estate companies and other thing. Maybe something like 20 to 25 lakhs would have been an appropriate amount, but they have gone to the other side of it. 1 crore is too large an amount. There are many cases where the amounts will be much less than 1 crore. So this has been widely touted to give a relief to MSMEs. In fact, this is what Finance Minister also has said in her statement, that this particular thing has been done to protect MSMEs during the crisis period in COVID. But I have my doubts about that, because what I feel is that in many cases MSMEs, when they supply goods and services to companies, various corporates, right, they are never more than a crore. By nature itself they are a small and medium industries, so their the credit which they can extend will be in the range of something like 10 to maximum 50 lakhs. I don't foresee any MSMEs giving more than a 50 crores loans or advances or supplying material and credit to any company. By actually making this increasing the limit to 1 crore, they themselves also suffer. The government has seen one side that if we don't make this amendment, people will go after MSMEs and file the cases against them, but they have not thought where these people will go. If today I am a MSME, if I have to recover something like 20 to 40 lakhs, earlier I used to go to NCLT, which was treated to be more effective or a faster redressal mechanism. Now that door has been closed to me. If I file a civil case, maybe it will run to decades together. So actually this amendment may be actually affecting MSMEs more than anybody else, are giving protection to MSMEs. When a question has arisen, whether it is a prospective or retrospective, in Fiesco India Limited case by NCLT Calcutta bench has held that nowhere in the notification it was held that it would apply retrospectively. Therefore, the amendment shall be considered as to be prospective in nature. So, all the limits which have been prescribed, they are not retrospective but prospective in effect. Now coming to the Insolvency Bankruptcy Code, Second Amendment 2020 came effective from June 2020. So notwithstanding anything contained in section 7, 9, 10, all these sections by which you can make an application by a financial creditor, operational creditor or the corporate debtor himself, no application for initiation of corporate insolvency process shall be filed for any default arising on or after 25th of March for a period of 6 months or such further period not exceeding 1 year from such date as may be notified on this behalf. So from 25th onwards, right, though the amendment has come in June, right, the retrospective effect is that all the dues which are from 25th March 2020. So any amount of default, whether it is 1 lakh or 1 crore, whatever amount of a default which has happened on or after 25th of March is not treated to be default under these sections, and you cannot file a case against any corporate on this, provided that no application shall ever be filed for the initiation of a CIRP process for the debt for the said default occurring during the said period. So this period of maximum 1 year. Now actually 6 months have elapsed. It has been extended for another 3 months. As of now, it is up to 31st of December. Sorry, whatever the date is that, right? 9 months, right? So any default happening, not only you cannot file a case against them, but for all the future times to come together, this default is not treated to be a default. For example, on say 31st of December, a notification comes that this is no more effective. All the defaults which are happening from 1st of January will be treated as a default under these section 7, 9, 10. But whatever default happened from 25th of March, say to up to 31st of December, for eternity, they will not be treated as a default. Now the question comes, what happened before that? For removal of that, an explanation has been put it. It is hereby clarified that the provisions of this section shall not apply to any default committed under the said sections before 31st of March. So this exemption is available only for the default which are occurring on 25th March or afterwards. So there is a default. For example, there is a default which has happened last year or maybe in the January or February to an extent of 1 lakh at that time or 1 crore subsequently, right? So now if I have to file a case, it has to be 1 crore. So cumulatively or at one installment, there is a default up to 1 crore on February. So it is not that you are prohibited to file a case now or during this period. So there was always a confusion when this suspended word is being used. I always personally I kept the view this suspended word should not have been used, because by our orientation, when we hear of something suspended means for that timing that is not available to you at all. That is not the case. Suspension means suspension of treating that default during that period as a default. But all other things are going on. The cases which have been admitted, they are going on. The cases which you want to file pertaining to period of prior to 21st March are still admitted. So where is the suspension? So neither the the CRP process has been suspended, nor the IBB has not a lock has not put on the IBBI. But general perception is that there is no insolvency now. It's not the case. The insolvency is still there. CRP process is still there. IPs are still doing their business well, and thank God for that. So they still can file a case which is pertaining to the prior period before 25th of March. So this is the clarification is given that this exemption doesn't apply to the defaults which are happening prior to that. It is applicable to defaults which have happened after 25th of March, and whenever it comes to an end also. It is not that subsequently you file a case against defaults which happened during this period. This has also been clarified. Till eternity, these defaults will not be treated as a defaults. So this is the important clarification. Now my concluding slide. Did the measures taken by the government bear the required fruits? I feel that Government of India, MCA, IBBA has shown a lot of dynamism in amending the code and regulations as and when required to address various issues relating to the real estate sector. Ever since IBC has come, if there is one sector for which amendments have been done, largely it is only real estate company. All the other amendments which have been come are pertaining to the operational part of the code, and giving clarifications or adding certain things, giving explanations. But as far as the real estate company is concerned, the maximum number of amendments have done to benefit the flat buyers. But unfortunately, as we have seen that a lot of special rights and privileges were given, because a lot of clarifications were given that they should be treated as a financial creditor and other things which we have discussed, and their interests have been protected. They are given equal rights as far as the attending of the COC meetings are concerned, or as far as voting is concerned, and attending through ARs and other things are also concerned. But all these have not resulted in a quick and acceptable resolution of the real estate projects. But unfortunately, whatever we thought that all the problems which are facing the real estate company by taking time to the CRP process will be addressed, has not come to be true. and the one of the main reasons for it is that by the time the project has been brought, the company has brought to CRP process, already unfortunately the promoters do such things that to put the real estate company in a very bad shape. So this is the most important thing, that as you filed an application, as you got a thing admitted, but ultimately the resolution applicant see what is it is worth. Is there any meat in that? So anybody today, suppose if I am trying to bid for a project, I'll see is there any worth in the project. If already the project is in a bad shape, it is not completed at all, or if suppose only 20-30% project has been completed and money has been collected and siphoned off, and you are not able to trace back the money, and you are not able to bring back the money to the company, then why should I be a resolution applicant and take that project? It will be a liability on me, a huge liability on me, and ultimately every businessman wants to enter into any project to make profits. If I don't see any profits, if I don't see any peaceful existence, why should I bid for that? So another thing which during the CRP process, the biggest problem I have been handling some cases, and I have been here in few cases. What I see is that in all the projects there are large number of associations, are either registered or unregistered, or they get formed into associations, and there is a bitter rivalry, inter group rivalry among the flat buyers themselves. So you will not find a real estate company which is going to CRPC without having different associations pulling things from different angles, and all the people involved in the process, especially the resolution professionals and the ARs and other people, get so vexed. And not only that, other financial creators like bank and other people. For example, today if there are banks and institutions who have only 10% of voting, right, 90% of the voting with the flat buyers, and they have 3-4 associations. So again there will be lot of jamming happens in the COC meetings. Nothing moves, nothing gets voted because of the rivalry among their own people. But they are actually hitting axe on their own legs, and it is not serving anybody's purpose. So ultimately, because of all these reasons, prospective application don't see any meat in the projects, and they shun away from such projects. Ultimately, many of the projects go into liquidation, or are on the verge of going into liquidations. So this is all my presentation. If you have any questions, you are most welcome to ask.